Alex here with part 89 of the My Docket series on child custody and visitation. As with my previous videos, I will take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series has to do with giving my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We move on to a motion to modify child custody. This is the first motion that I have filed to modify child custody. The previous order that the court entered on custody was actually the final order in the case. It wasn't a modification, it's just the custody that was awarded. And it was joint physical and joint legal. And at this point, I have decided it's time to seek primary physical custody. The reason at this point, however, is based on education. For those of you, I think it was in the previous video, it may have been 2 videos ago, I went over an affidavit from my son's kindergarten teacher that outlined a design, I guess you could say it was a design, a pattern, a system, an approach that my ex put into practice where she was trying to get him kicked out of school. And I do believe that some of that evidence, or at least the offers of proof, had come up probably in the last 4 or 5 videos, emails here and there, and then of course the affidavit about my ex just trying to be as stubborn as she possibly could with the school, not wanting to force him to wear the required uniform. And later on, she just stopped taking him to school. And I probably am not going to talk too much about this now because it's going to come out in the exhibits of the actual motion that we're going to go through. So I think that might be the best time to talk about some of the things that she was doing to try and get him kicked out of school. And I think I'm going to reflect a little bit on my ultimate withdrawal of the motion when I actually file that. I have a lot to say about this because this was the first time I went from I want to have shared custody, we're both equal parents, to we have a serious problem here. I need to get as much custody as I possibly can. This is the first time that happened, and at all stages of this process, I'm going to have a lot to say. But for now, we really need to get started and just go ahead and take a look at what I have filed. Here we have the motion to modify custody and for order regarding education. I don't know why it feels like deja vu every time I have to deal with something regarding education. So I am filing a motion to modify custody and gosh, I wish I could remember what I dealt with last time I filed it. I think it was some kind of it was like an ex parte temporary restraining order, or maybe it was a contempt motion or something like that. I don't remember now. But here we are again having to deal with the education issue. So, introductory paragraph, pretty standard. I identify myself as a petitioner, that I am appearing in proper person, which means I don't have an attorney, and that I am trying to file this motion to modify child custody. Going into the memorandum of points and authorities, the factual background. First fact asserted is probably a summary one. Yes, it looks like I'm the father, my ex is the mother. I sued her for custody and visitation over our common child at age 6. Next assertion is that the court awarded both of us physical and legal custody jointly. Next fact asserted is that I, through my attorney, and my ex, through and by her attorney, convened before the court on a hearing to determine whether or not our son would need to go to Coral Academy of Science. On August 9th, 2011, our son began his education, and the school uniform issue is coming out. I allowed my ex to share the school uniform. Just so many bad memories about this process. So I was trying to be nice, and I said, hey, let's share this uniform. She just kept it. And the attitude I still remember to this day. I said, "Hey, here's his uniform. Let's work together and share." And she took the uniform and responded, "Nope, go buy another one." And this is just one example. She got much worse. Next assertion is that the court entered an order regarding the aforementioned hearing, which is the written order. The next assertion is that we convene before the teacher and the dean and determine that it would be in our son's best interest to delay his education for a year. The next assertion is that I filed with the court the declaration regarding the agreement to continue our son's education at Coral. Our son resumed his education the next year roughly at Coral under the same kindergarten teacher. The next fact asserted is that I asked my ex to please provide the homework packet. Apparently this is when she was not returning the homework packets. So we've got two things going on. I filed a second declaration from our son's kindergarten teacher, and this one deals with my ex's disparaging remarks, her intentional disobedience to the school rules, her refusal to report our son's absences, and the unfortunate truth that her conduct so far had become far worse, to the point where the teacher put in writing under oath that my ex was intentionally trying to sabotage our son's education. I'm not sure how many teachers would do that without really hesitating. This teacher must have really been concerned to put down in writing under oath that my ex was sabotaging our son's education on purpose. Filed a notice of intent to modify custody, warning my ex that she had to change her conduct and follow the school rules because his education was suffering. I discussed disciplinary issues with my ex. She ignored him. No response. I discussed another disciplinary issue with my ex. She again ignored it. And then we go into the next assertion, which is that I was notified that my ex had not taken him to school 4 times, nor was she notifying the school of the absences. And I cite the Washoe County School District rules. I emailed my ex advising her to call the school, and I also asked her why he was absent 4 times. Next assertion is that I was notified by the discipline coordinator from the school that he had an incident and he had to be removed from the classroom and picked up by my ex. I was further notified telephonically by the teacher that cooperation with my ex was virtually non-existent. She's doing this on purpose, guys. She wants the school to say something like, "Since you're not complying with the rules, we're kicking you out of school." This is what she wanted. She wanted to somehow defeat the court's order by this roundabout way. I notified my ex that our son had not received, or that I had not received the homework packet. And then I notified my ex's attorney that I intended to file a motion to modify custody, and that let's see here. Next assertion is that to protect our son's. No, that's the same paragraph. I was notified by another teacher. Oh, this is the receptionist. This is my favorite part here. The receptionist at Coral Academy had notified me that my ex had failed to take him to school another 3 times and was still not reporting the absences. So that brings the total of unexcused absences to 7. Oh, okay, so this isn't the best part. There is a better part where she tells me one of the reasons as to why my ex doesn't take him to school. It may come up the second time I try to file a motion to modify, so I'm not sure. Here we go. On October 11th, I was notified by the teacher that my ex had turned in Army's homework on weeks 1 and 2, but failed to turn in Army's homework for weeks 3, 4, 5, and 6. I forgot about this. There was she just didn't do the homework at all. She just didn't do it. Anyway, the teacher was concerned that my ex had not been sending him to school with a backpack, nor with his water bottle, which is a requirement at Coral Academy of Science. It's to reduce interruptions so the kids don't have to constantly go to the water fountain. Okay, so yeah, this isn't the one. It looks like my ex's child support arrearages remain unpaid, even after debtor's examination and the issuance of 2 writs of execution. However, she will pay this. Eventually, this writ of execution will land and the money will be seized. One thing I wanted to mention is I was talking about my favorite part of the absences, which hasn't come up yet. Apparently, that's what comes up the second time, because I do file a motion to modify child custody again after this. And what happened was she called the school and she told them that he wasn't going to go to school. And when they asked her why, she said it was because he didn't want to. That's what she told them. And I actually got an affidavit. So you will eventually see an affidavit from the attendance keeper stating Ms. Farrar called the school and claimed that the child would be absent because he didn't want to go to school. That was it. Anyway, it's not up now, but it will come up. Legal analysis. Res judicata is overcome by a substantial change in circumstances. For those of you who haven't seen my video, Change in Circumstances, I strongly recommend you take a look at the video, Change of Circumstances. That goes into how it works in Nevada, and I think most of the states. There is one more component to that applies in some states, not ours, and I talk about that in the video, Modification Trauma. They have another, they refer to it in a different way in these other states. It's something like, I wish I could remember now, but it has to do with showing that the modification is not just in the child's best interests, it's also in the child, it's also in a sense going to outweigh the amount of trauma that the child is going to suffer by sort of uprooting them. There's a phrase that they use in these other states for that third criteria. I think it's 2 criteria that we cover in the video, substantial change of circumstances, and then there's that additional 3rd criteria. Anyway, going into it, Ms. Durio, which is the kindergarten teacher, declared under penalty of perjury, and I already went over this declaration, so I'm going to skip these portions. If you have any questions about our declaration, just post it down in the comments below. Next assertion here is that supporting the allegations of intentional sabotage of our son's education are the 7 unexcused absences for which my ex is responsible for, her intentional disobedience to the school's rules, and her marginalization of Army's behavioral issues. Next paragraph here has to do with the best interest of the child involve enjoying a healthy educational experience. And I cite subsection 2 of 125.510, which indicates that the court can modify or terminate its own custody orders on its own motion or based on one of our motions if it is shown that the best interest of the child requires the modification. The statute is reinforced by a couple of cases, and Mosley v. Figliuzzi talks about how to deal with the conflict between the parties. Truax, I can't remember what that has to do with, but apparently, taking a look here, it's talking about if it is shown that the best interest of the child requires modification, then any order for joint custody may be modified. Now, that's pretty straightforward. And then we got a Mack v. Ashlock citation, which talks about the sole consideration of the court is the best interest of the child. It's not entirely true. You also have to look at the change of circumstances threshold question, which I already talked about earlier. Definitely take a look at that video, guys. I could spend 30 minutes talking about it now, but there's no point because I already dedicated a video to the topic. It's not one of those videos that you should just skip over. You should watch that video. We go into another portion of our declaration, which I'm going to go ahead and skip over again because we already talked about this. There's a possibility of underlying psychiatric issues. Let's take a look at this assertion. My ex's spite of Coral and defiance of the court's decision to order Army to attend Coral is understandable. No, it's not. Well, I guess it is understandable that she's unhappy with it, but it's not understandable the actions that she's taking. Anyway, it is beyond normalcy for any parent to deliberately sabotage their own child's education. Okay, so that's kind of covering what I was talking about. I am concerned that certain mental illnesses may have been overlooked upon examining my ex's psychiatric records on file, and these records were only briefly glazed over by the court several years ago, and I was not allowed to review them. I've already talked about this before, but it was a mistake for me to not review those documents. The court had no right to keep those documents secret. The court could only determine whether or not the documents were relevant. If the documents were relevant, the court was required to turn those documents over to me. It's really upsetting to me to not know this at the time, and for the court to have taken advantage of my ignorance, taken advantage of the fact that I didn't have an attorney and keep those documents secret, because those documents could have really reduced the pain that our son would have suffered. And it's just, in my opinion, egregious. The court should consider ordering my ex to attend a psychiatric exam. Okay, I have a different opinion on this approach now. I used to think that this was the right thing to do. I talk about this in the video Evaluating Mental Health and a little bit in the video Narcissistic Personality Disorder. And now I have a different opinion about using psychiatric examinations and mental health experts. And I've talked about it in those videos, so I don't want to speak too much on it now. But I will say this. If you try to make the issue a mental health issue in court, 2 things are going to happen. Number 1, your costs are going to skyrocket because somebody's going to have to pay for that psychological examination. And a lot of times the courts want the costs to be split. The costs are very high unless you go with one of the discount ones. And the bad thing about those is you're going to get just shoddy service. The therapist is going to very quickly glaze over what's going on, and the chance of them making a mistake is a lot higher. That being said, even if you do spend $20,000 to $25,000 on an exam, there's still a chance that the expert's going to miss it. And I can't underline enough the importance of taking a look at Dr. Steve Miller's testimony before Congress on this issue. There are a lot of experts out there with regards to mental health, but according to him, the best thing that you can do is find an expert that deals with personality disorders, because if you find an expert that's just generally really smart about mental health and psychiatry and psychology, they're not necessarily going to key in on the sort of niche symptoms and phenomena that occur with somebody who has one of these personality disorders. It's just according to him, too much of the field is counterintuitive. It is too easy for them to dupe one of these experts because of the counterintuitiveness of some of these things that they're going to see that are going to look a certain way, but without the experience that a mental health expert on abnormal psychology or personality disorders has. There's a potential that they'll still miss it. The last thing that I want to mention is that too often when they pass this psychological or psychiatric exam, they use it as a shield to sort of minimize the abuse that they're committing. What I'm trying to say is they'll say, okay, yeah, Your Honor, I did do these abusive things. I did do these neglectful things. But since I passed the psychiatric examination, it's okay that I did those things. Since I'm not a crazy person, the abuse and neglect that I'm committing on our child is not that bad. It should be allowed to continue. You should trust me that I'll stop doing it. So because of that, all of those things that I mentioned, I've drifted away from this approach, and now I just think that the best thing you can do is focus on their actions. Don't worry so much about the mental health that's causing the actions. Just focus on the actions. Your ex is doing A, B, C, and D. These things are not consistent with the best interest of the child. For those reasons, custody should be modified. If they want to raise their mental health on their own, let them do that. If they want to say, Your Honor, please forgive me, I have borderline personality disorder, I'm going to go get treatment, let them bring that up. Let them spend that money. Let them jump through those hoops. Make sure you try and get some kind of temporary order at least while they're trying to get treatment and medication and stuff. But I don't think it's a great idea anymore for the person who's trying to fix the situation to bring up their ex's mental health. Your ex, on their own, let them bring that up. Let them use that as a shield. Let them do all the work associated with that if that's what they want to do. If they want to play the angle, I have abused and neglected our son because something is wrong with my mental health, they can play that and they can do all that work. But you just focus on the symptoms, focus on their actions, focus on what they're doing. Definitely watch those 2 videos because there's a lot to what I'm saying here. And definitely, if you get a chance, watch the testimony by Dr. Steve Miller to Congress, because he explains why this mental health stuff, this approach is backfiring on a lot of people in the courtroom. Moving on to, the court cannot punish parental misconduct absent a specific order. And I'm citing a law here about contempt of court. And this is true. And I've talked about this in the video, Many Fine Lines. I'm explaining to the court, you cannot fix this problem by just constantly telling my ex how to do her job as a parent. You just can't do it. And anytime he tries to do it, she just finds another way to get around the court's order. So this is going to have to be dealt with custodially. This is a custody issue. This is the best interest of the child issue. And I talk about these 2 different things in the video, Many Fine Lines. Please watch that video because there's a lot more to what I'm just going over right now, because this is just a video on a specific paper that I filed. Modification of timeshare. Looks like I'm asking to close the second gap. That's exactly what I'm asking here. So I was able to close the first gap on the hearing where we actually got the school set to be choral. And there was 2 midnight exchange gaps then, and now there's 1 midnight exchange gap. And here I am trying to close that second midnight exchange gap. Costs. So I'm asking for an awarded costs. I've talked about this before, and I don't know if I'm entitled to costs. I know I cited a case here, McGee versus Whitaker, but I'm still quite doubtful. I'm not going to look into it anymore. You know what? Take a look at my video, Attorney Fees and Costs, because I talk a whole lot more about how you have to go about getting an award of attorney fees or costs in that video. So I'm going to avoid going over it again now. Hearing. This is the first time, I think anyway, that I try and get out of mediation. Or maybe, no, it's not. This is not. I'm just citing the local Rule 44, subsection 4B. I know what this is. This is a different rule. This is a rule that allows me to file a notice to set. Yeah, there it is. I'm allowed to file a notice to set concurrently with the motion. I don't have to wait for the court to allow me to set a hearing. So that's what I'm doing here is I'm citing a local rule that states that. Conclusion. Basically, I'm saying it's great that he gets to go to charter school, to Choral Academy of Science, but my ex is trying to find ways around it. She's trying to ruin his education. Moving on. Looks like we got my declaration under oath. This is just me stating under penalty of perjury that all the facts alleged in this motion are true. Rule 5, certificate of service, indicating that I served the document upon my ex's attorney. And we've seen these motion opposition notices many, many times before. I am checking all of the boxes, and it looks like here I might have to pay. Let's see. Final decree, custody has been entered, yes. Is it in motion or in opposition to change a final order? Yes, it is. Is it a motion or an opposition to change the amount of child support? No, it's not. And is it a motion or an opposition for reconsideration of a new trial? No, it's not. If the answer to question 4 is yes, right in the final, no, it's not. If you answered no to either question 1 or 2, or yes to questions 3 or 4, you are exempt from the filing fee. However, okay, so according to this, I have to pay the filing fee. So we're looking at a $25 filing fee. I think this is the first time that I may have had to do this. List of exhibits. We've got 9 different exhibits here. Exhibit 1 is the affidavit that we already went over, so I'm going to skip that. Exhibits 2, 3, 4, 5, 6, 7, and 8 are emails. So we will go over those. And Exhibit 9 is a proposed timeshare illustration, so we'll go over that as well. And again, as with my previous videos, anytime I skip over a document, just keep in mind, number 1, it's down in the description below. Just click on the link to download it. And number 2, I've already gone over it. So if you find the my Docket video that I went over it on, you can actually watch my analysis on that particular document that I skipped in this video. Okay, first email. Do you have Army's homework packet? Sent to my ex. No reply. Second one, again from my ex, or from me to my ex. I'm not used to having Army on Monday, so I realize now that I have the homework. Would you like me to leave a few days open for you to do some with him on Sunday? Just trying to be nice. Army had a very bad day. Apparently the music teacher gave him a write-up for fighting with another boy. Got an extra copy for you. And I don't think she responded to this either. Nope, no response. Okay, Army had a very bad week entirely. Grounded him from the weekend. No TV, no playing. You can also let me know if he's had a bad day on Wednesdays. I'm trying to co-parent basically, but no response. Okay, they told me that Army was not in school today, and that if you aren't going to take him to school, to call in advance and notify them why. Apparently this has happened 4 times. Yeah, she's not telling me about this. I'm finding out just now. Looks like no response to that. This one's from the teacher to me. Good afternoon, discipline coordinator. I understand that you need to be contacted when something happens at school. Army had to be removed from the classroom. He was spitting on neighbors, poked a student in the eye. My ex was contacted about 9:56 a.m. She stated that someone would come pick him up. Uncle, there's no uncle. It's just somebody that she called an uncle. He wasn't actually an uncle. She had this thing she would do where she would make friends with people and give them familial roles. Anyway, that's the school letting me know. Here's me telling my ex again that I didn't get the homework packet. She does eventually get held in contempt of court for this, by the way. October 3rd, no reply. And here we have me trying to let my ex know. Oh, the attorney know if she has a preferred date and time for the hearing to let me know. I cite Rule 44, subsection 4B, and I don't think the attorney even responds to me. Looks like... Nope, no response. Wait, is there? Okay, so here we have a response. I'm going to start with that. Hi, Alex. What motion do you intend to file? Otherwise, or of course, I'm open to discussing any proposals so that we can avoid further motion practice. I really started to get along with my ex's attorney. I mean, there was a lot of things that she did that I thought were unscrupulous, but all of that being said, I still got more done with my ex's attorney than I got done with my ex. And then here's my response. Appreciate your cooperation. I was thinking of attempting to get primary physical based on the kindergarten teacher's allegations. As you're aware, I filed the affidavit of notice of intent. I was hoping that would be enough to correct things, but they're just getting worse. And here we have Exhibit 9. Okay, so it looks like the top one, what is going on here? So it looks like the bottom one is, I don't know what this is. It kind of looks like I'm proposing this weekly schedule, which has no gaps. The one on the left-hand side, and it looks like the right-hand side schedule is an alternative that I'm proposing for my ex. I mean, it still closes the gap, but it gives... Oh! Now I understand what's going on. It looks like the left schedule is if the court decides to keep joint physical custody, but it closes the midnight exchange gap, so there's no more midnight exchanges. And it looks like the right schedule is if the court actually grants my motion to modify child custody, and that creates a sort of every other weekend. It looks like on one week, we still kind of have the same amount of time together, and then on the other week, no, she loses a chunk of time here on Wednesday, and then on the other week, she only gets to see him for Saturday. Here we have the notice to set. And I'm just citing the local rule that allows me to file a notice to set concurrently with my motion to modify. And then I'm setting the dates and times here for when we are going to set. Please watch my video, Notice to Set, because you're not going to understand what I'm talking about, most likely, until you watch that video. And I'm going to avoid talking about it now since I dedicated a video to the topic. Here we have Certificate of Rule 5 service indicating that I served the notice to set upon my ex's attorney. Going into the aftermath. I filed 2 documents. One of them was a free filing, but the other one was not. I had to pay a $25 filing fee, so that cost me $25 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, she would have probably spent a long time, not to review, but to communicate with my ex. But I think I'm going to put that time under the opposition that she files. It's more realistic to think that the attorney spent most of the time consulting with my ex when she actually had to prepare the opposition. So I think to just review my motion and to maybe briefly confer with my ex, I think it's reasonable to say that she spent a half hour on that. At the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.